Hey, I'm Paul Rabelais. So in this video, we're going to go back to the basics and talk about wills and trusts explained. All right, so I got a lot to go over in a short period of time. We're going to go back to the basics, but before I do, let me go over a couple of housekeeping items. I've been thinking about this for a long time, trying to figure out what to do, but I made a decision. It's a big announcement. It's a big decision. So if you're interested, I'm going to be publishing a video on YouTube every single day at 10 a.m. Central Time. In the past, it's been kind of when I get around to it, when I have time, when I feel like it. But you know what? I wrote down a list of things that I can educate the public about that they often get confused about. That combined with the fact that we're getting so many really nice comments either in the comments below in the YouTube description, or frankly, just people that I run into in my law office that tell me they get a lot of benefit out of the YouTube videos. I'm going to crank one out every day. So just check in with us, 10 o'clock Central Time every morning, new YouTube video. Love to see you get involved with comments and thumbs up and shares and all that stuff. So wanted to make that announcement. It's going to be a big challenge for me, busy with my law practice and my family and everything I've got going on. But if I plan it right and get to work, I really think it's going to be a win-win there for myself and lots of other people, and especially those viewers out there who want to learn as much as they can about the estate planning process. All right, so that's my big announcement. All right, let's go back to just the basics of wills and trusts. All right, so let me kind of really start with the beginning. People acquire stuff while they're alive. The typical assets that people acquire while they're alive are their home and other real estate. Some people acquire retirement accounts through their 401k at work, sometimes through IRAs. People have bank accounts. People have other investments that are not part of their retirement accounts. People have vehicles. Most people care about what happens to their stuff when they die. And there are certain assets that you can leave to your survivors by way of a beneficiary designation. Things like your 401k and your IRA, your life insurance. When you set those up, you fill out a beneficiary designation form where you designate who you'd want to get that account or that asset when you pass away. If you're married, maybe it's your spouse as the primary beneficiary. Maybe if you're married and have kids, maybe it's your children as the secondary or contingent beneficiaries. And those beneficiary designations control, even if you have a will, those beneficiary designations on those types of assets like retirement accounts and life insurance, they control, and so that's covered. Now, there are certain assets that are in your name that when you die, because of the type of asset that it is, your state law doesn't permit you to designate any kind of beneficiary. So if you die without a will, then the state, your state where you live, determines who gets that. Most people have a will, so they get to determine, who gets their stuff when they die that isn't disposed of in some other form like a beneficiary designation. Now, if you're going to have a will, it's got to be a valid will. So you have to meet the validity requirements of a will. We get questions about that sometimes. So here in my state of Louisiana, there's two types of valid wills. There's the notarial will, which gets all typed up and it's done by lawyers, and it has certain language in there that is absolutely necessary, that has to be in there. It gets notarized, it gets witnessed by two people, and if you meet all of the requirements, it's a valid will. And then in Louisiana, we have the oleographic will, which is entirely written and dated and signed in your handwriting. Pretty easy to meet the formality requirements of the oleographic will. Where sometimes people get tripped up is they don't know what wording and what language to use. So I'm going to post a video up top, or a series of videos on types of valid wills in Louisiana, so you can learn more if you want to. Okay, so it must be valid. Here's some of the other reasons people have wills in Louisiana, other than just to say who gets their stuff. So parents with minor children, they're going to want to have a will and name the backup parents or guardians, or what's called in Louisiana tutors, of their minor children, who has the right to raise their children if the parents die before the children reach the age of majority, which in Louisiana is 18. And also in your will, you'll name an executor. You'll probably name a backup or alternate executor. That's when you die, who's going to have all of that ability and authorization to do what they need to do to make sure that the terms of your will are followed and everybody gets what they're supposed to get. Okay, so in a will, there's, every will has some standard things. There's that introductory sentences or paragraphs, which is where you declare it to be your will and you revoke any prior wills. There's all of the bequests provisions of your will. That's where you leave things to your spouse, to your children, to others. And then there's the miscellaneous provisions of your will, where you name your executor and handle any other miscellaneous aspects that need to be addressed in your will. But I will tell you that the overwhelming majority of wills out there, your specific assets are not listed in your will. So we don't go through and list each specific item that you have. You don't have to have a list of your home and your accounts and all that to make a will. The overwhelming majority of wills out there may say something like, when I die, whatever I own goes equally to my kids. So that's common. Or whatever I own when I die goes to my spouse. And if my spouse dies before me, when I die, whatever I own goes to my kids. So that's kind of the simplest of the scenarios, and that's real common. Sometimes people do want to get a little bit more specific. I leave $25,000 to my niece and also $25,000 to my nephew, and everything else that I own goes to my kids equally. Sometimes there's some specific bequests of property. I leave my home to my daughter, and I leave everything else to be divided up in 4 parts. 1 part to be divided among my grandchildren, and the other 3 parts to each of my 3 children equally. So sometimes there's some of that little bit of specificity in there. You got to be careful because people's assets change after they write the will. So you got to be careful when you put that specificity in there. All right, so that's the kind of basics of a will. Now I'm going to start touching on some of this trust stuff, and I'm going to get into trust even more in a little bit. But as I finish up the will conversation, I have to include one form of a trust that is included in wills sometimes. So sometimes in people's will, it's not uncommon to include trust provisions in your will. It's one way trusts are used. Let me give you a few examples. Your kids are young, you want to leave, or you and your spouse want to leave assets to your children, but they're 12 years old or they're 10 years old. They're minors. So your will is likely to say, if I pass away or after me and my spouse pass away, I leave what I have to my kids in a trust, and I name my brother as the trustee of that trust. And if my brother determines that my kids need some of the trust assets for their health, education, maintenance, and support, we call it the HEMS standard, HEMS, then my brother has the discretion to use the trust assets for my children's needs. And then at some later date, maybe you put age when your children reach the age of 25, then whatever's left, your brother, the trustee, would turn it over to your children at that time. So when it's done that way, the parent created a will. Inside the will, there is what's called a testamentary trust. It's testamentary because the terms of it are in the parent's last will and testament. So sometimes people say, well, I know that my brother set up a trust for his kids, but there is no trust instrument. I'm like, the terms are in his will. So we see that sometimes. We see sometimes people making a will with a testamentary trust when they have an adult heir who was not financially responsible. 70-year-old, dad writes a will. I leave my stuff equally to my three kids. My 2 oldest kids, they can have theirs outright. My youngest child, his portion is going to be in a trust. Either the bank's going to be the trustee or his other 2 children will be co-trustees. And it's going to be doled out to that 3rd child under the terms of the trust, because dad feels like it would be a bad thing to leave that child a lump sum of an inheritance. He might be on drugs or be on jail or have a very influential wife who's going to spend all of the money, whatever the case may be. There's 1,000 stories. So that is another form of a testamentary trust. Some people in their will, some married people in their will, and we see this a lot when married couples have children from prior marriages. A married person might say, and in his will, it might say, when I die, I leave my assets to a trust for my spouse and then for my children. And my spouse, if my spouse needs to use my assets after I die for my spouse's health, education, maintenance, and support, those assets can be used for my spouse's needs. But then when my spouse dies, I want whatever's left in that trust to go back to my children. So that's a way to provide for the spouse, but then protect your children instead of leaving it to your spouse and having your spouse control where it goes when your spouse dies. So that's another form of a testamentary trust. Sometimes people create a will and they leave assets to a child in a special needs trust. Maybe that child is receiving certain government benefits because they're disabled, and so parents can leave assets to that child in a way that their government benefits aren't jeopardized. Parent leaves assets to a special needs trust, another form of a testamentary trust. Okay, so my point there was people have wills to control where their things go. Yes, they have beneficiary designations on retirement accounts and life insurance, and sometimes even other assets, but their will controls where their other things go when they die. And in some cases, in those wills, there are testamentary trust provisions if it was necessary for any of the reasons we just described. Now, when you leave things to your heirs through your will, you will have left all of the assets in your name. And when assets are in your name and they're not retirement accounts and life insurance where you have a designated beneficiary, those assets, when you die, even if you have a will, they're going to be frozen. And your executor and your heirs will hire lawyers like myself, and it's just the way it is. We've got to guide the family through a court process and prepare lots of court pleadings and inventories of assets and submit lots of stuff under the procedural rules to the clerk of court and the judges' offices, because judges need to sign various court orders ordering the transfer of assets from your name to the names of your heirs. Many people call that process probate. In Louisiana, we call it a succession. It's just when you die with something in your name, whether you have a will or not, your survivors are going to have to go through this court process, because it was determined a long time ago that our courts and our government were going to oversee the distribution of your assets that are in your name when you die. Okay, so I had to give you all of that background as we now really kind of dig into, trusts explained. I thought about, how do I describe that? So let me give you the legal mumbo jumbo definition of a trust, and then we'll get into the practical uses of it. So what is a trust, and what's the definition of a trust? Well, the legal mumbo jumbo definition is a trust is the relationship resulting from the transfer of title to property to a trustee who administers it as a fiduciary for a trust beneficiary. All right, so that's, like I mentioned, the legal gobbledygook. So let's look at some practical uses for trusts. Here's some of the reasons. I've already explained some of the reasons why people use testamentary trusts. And look, there are testamentary trusts and there are standalone or inter vivos trusts. More on that in a minute. But here's a reason someone would want to transfer assets to another trustee who administers it on behalf of one or more beneficiaries. Okay, so one of the popular reasons people use trusts is to avoid the probate that I talked about a minute ago. I mentioned that probate is necessary if you die with assets in your name, even if you have a will. So what some people do in an attempt to avoid that court supervision and that government and attorney involvement when they die is they transfer assets to what they call their living trust, their revocable living trust. So John Doe transfers assets to John Doe as trustee of the John Doe Revocable Living Trust. And the trust says it's all for John during his lifetime. Says when John dies, then his son Fred is the trustee, and it says that John's 3 children are the principal beneficiaries of that trust to receive the trust assets when John dies. John dies, nothing's in his name that's frozen, and it's got to go through the courts to be transferred. Fred, the day after John dies, starts transferring assets out of the trust to the 3 beneficiaries. So many people use trusts to avoid probate. Another reason people use trusts, and here it is, the early January, and I did a lot of this in December, was people trying to avoid estate tax. So I'll post a link to another video that talks more about that, but the quickie version is some wealthy people want to get assets out of their estate before they die, so those assets avoid the 40% estate tax when they die, but they don't want to just dump assets into their grandchildren's names, so they'll often set up a trust for the grandchild. They'll say something like, I'm going to set up a trust for my grandchildren, and I'm going to name my child as the trustee. I don't want my 16-year-old grandson getting his hands on $30,000 or more. I want his father to be the trustee of it and to use it for the right reasons. And then when my grandson is older, maybe when he's 30 or maybe when he's 25 or whatever that grandfather thinks is appropriate, then any remaining trust assets can then be transferred over to that beneficiary. So it's a way to get assets out of your estate but not put them into the hands of an irresponsible heir. So that's the avoiding the estate tax trust. Some people avoid assets in order to get assets. Some people use trusts in order to get assets out of their name for nursing home purposes. I'll post another video on that, but the general idea, get assets out of your name into a particular type of trust. Do that at least 5 years before you go into a nursing home to comply with the Medicaid, long-term care Medicaid rules. And then when you go into a nursing home, you're not subject to all of those rules where you have to spend down all of the assets that are in your name until you have less than $2,000 remaining. Some people use trust to protect irresponsible heirs. I've touched on that a little bit, where dad has 3 kids, one of whom cannot handle money, and it would be bad news to leave that kid $250,000, $500,000, $1 million, $100,000. So dad directs that when dad dies, that child's inheritance will be in a trust to be managed, maybe doled out monthly or annually over many, many years, and the child will be able to benefit from it for many, many years rather than getting it in a lump sum and blowing it. Some people set up trusts for special needs children, and I mentioned that earlier. Sometimes this is done either through a testamentary trust in the parent's will, or maybe the parents set up their own stand-alone or inter vivos trust while they're alive. Either way, but parents often leave assets to a trust for that special needs child, so that the child, 2 reasons. 1, the child's government benefits aren't jeopardized, and 2, the special needs child may not have the capability of managing an inheritance the right way. Another really common use for trusts is this leaving things to your spouse in a way where you're making it available for your spouse's needs, but then when your spouse dies, reverts back to your heirs, your children, your grandchildren. That's another reason people use trusts. I've mentioned a couple of times, worth saying again, all trusts are either testamentary trusts, the terms of which are in your last will and testament. And if there are assets in your name when you die, there will be a court proceeding required to get the assets from your name into that testamentary trust. And then there are standalone trusts, where you set up the trust while you're alive, and before you die, you transfer assets of yours from your name to your trust, because that was beneficial for some reason, either to avoid probate or to avoid the nursing home problem or to get it out of your estate for estate tax purposes or some other reason that was appropriate. Okay, so anytime we have a will and trusts basic discussion, we also have to address the incapacity planning or the power of attorney and living will stuff. So all this stuff we've been talking about specifically with your will doesn't have any legal effect until you die. And then when you die, then your executor is in charge of making sure that things go through the court process the right way and assets wind up in the names of the heirs. But that doesn't do any good for you if you're alive but incapacitated. And if you don't have these powers of attorney, in fact, then someone's going to have to sue you in a court proceeding, have you declared incompetent, have a judge designate a legal guardian on your behalf. And you can avoid all those court proceedings typically by having a power of attorney in place. And a power of attorney is only effective while you're alive. Its effectiveness stops when you die, and then the executor of your will starts to take over. It might be the same person. But in your power of attorney, you'll likely say, you know, if I get to a point where I'm not able to sign my name and handle things, I want this person, and in the alternative, this other person to be able to do stuff for me. And whether that's be able to do things like handle your banking and your financing and making your medical decisions. And then most people consider having a living will in place. People who execute a living will typically don't want their family to have to make the decision to withhold or withdraw life support if you're a vegetable with no chance of recovery. So there's a little more to it than that, and I'll post another video describing more about the living will declaration. Okay, so you might need to go through this a couple of times just to get the basics and understand the basics of wills and trusts. There's a lot more to it, hence 300 other videos that are on my YouTube channel. But I wanted to just give you the basics for those who are just getting started on thinking about getting their estate legal affairs in order. It's something that really everybody needs to do, and I think it's pretty obvious to most people that they need to do it. Some people just don't know where to start or don't feel like they don't know enough to ask the right questions. Maybe this will help with that. All right, so look forward to having you 10 a.m. Central Time. Check out the videos. Comments below if I missed anything, or if you want to describe any experiences or other comments you have in the comments below would be great. Thumbs up, subscribe, notification bell so you don't miss anything. We'll see you tomorrow.